Hello everyone, welcome to Sriram IAS, an Unacademy platform. Today we will discuss the important topic of defamation under the Indian Penal Code and the relevant provisions in the Indian Constitution. Defamation as defined in under section 499 and 500 of Indian Penal Code it refers to the imputation by one person against another. So this imputation affects the reputation of the other person and therefore leads to civil and criminal consequences. Now, is this a purely civil offense or a criminal offense? Should it be a crime? There is a raging debate in the country whenever a politician is hauled up for defamation, because the punishment for defamation is maximum is 2 years, and in the case of elected member of parliament or assembly, the minimum sentence which entails immediate disqualification is 2 years. So you find that there is a raging controversy about this provision, whether it conflicts with the freedom of expression guaranteed by the Constitution under Article 19(1)(a). Article 19(1)(a) guarantees the freedom of expression of the individuals, and Article 19(2) refers to reasonable restrictions and 8 specified grounds. So if you look at the Constitution under Article 19(2), one of the restrictions relates to defamation and contempt of court. So is the restriction reasonable? Can the expression be construed, the defamatory expression be construed as a reasonable ground for restricting the individual's right to freedom of speech and expression? I mean, there is a raging debate on this. Many persons had approached the courts to declare that Section 499 and Section 500 of Indian Penal Code as unconstitutional because of the constitutional guarantee of freedom of speech and expression. So the Supreme Court, a two-judge bench of the Supreme Court, had gone into this question in Subramanian Swamy versus Union of India. So Supreme Court in that case had gone into the various constitutional arguments for and against making defamation a criminal offense and declaring Section 499 500 as unconstitutional. So how did the court arrive at the conclusion in this case that defamation is not unconstitutional, is fully constitutional, as it safeguards the right to reputation guaranteed under Article 21. Article 21 of the Constitution, as you all know, guarantees the right to life and liberty, and the courts have interpreted reputation as an element of right to life and liberty. So therefore, because Article 21 guarantees implicitly the right to reputation of an individual, the right to reputation entails restrictions on freedom of speech in order to safeguard a person from, protect a person from defamation. So is that a crime? Is that a crime? A crime in the ordinary sense is referred to as something which is happening in the public. So the crime against the state. So can a crime between two individuals, can that be a crime? Can that be construed as a crime? So the court went into this question and arrived at the conclusion that even though it may happen between two individuals, defamation definitely affects individual reputation, and individual reputation is also intrinsically a part of the collective good. So if the individual loses his reputation, he loses the ability to participate in the collective social good, and therefore it is also to be recognized as a crime. So in that sense, the inconsistency is there an inconsistency between right to reputation and the freedom of expression? I mean, this is something which the court had gone into in much detail. Article 19, 1A of the Constitution, which guarantees freedom of expression, and Article 21, are they inconsistent with each other? So no two articles of the Constitution can be construed as inconsistent with each other. They have to be read holistically, and they have to be read together. So in that sense, what the courts have to do is balancing of these rights. So what does balancing involve? Can one say that because of Article 19(1)(a), the person cannot exercise the right to reputation under Article 21? Supreme Court said no. These two rights are distinct and they have to be balanced. They have to be given effect to. So therefore, they said sections 14. The Supreme Court said section 499 and 500 are constitutional because it protects the right to reputation. So right to reputation being an important ingredient of Article 21, Article 19(1)(a) has to be balanced. So how do you balance it? Article 19(2) provides the scope for reasonable restrictions on the exercise of fundamental rights on specified grounds. Now, the words reasonable have to be understood clearly. The words reasonable means that any restriction being imposed on the exercise of fundamental rights must be proportionate. So the word proportionate means that the restriction, if it is not required, should not be imposed on the exercise of the fundamental rights. So what is chilling effect? Chilling effect is, is a unintended consequence of any restriction. For instance, if a person is sought to be punished for innocuous exercise of freedom of expression, he may be thinking that he is cracking a joke, but this joke is misinterpreted to mean an offense of defamation, and the case is foisted on him, and the person is sent to jail. Then it has chilling effect on the rest of the society, because the people will think that we have to be very cautious while speaking, and even jokes are not allowed because it may be construed as defamation. So therefore, it has got a chilling effect. The chilling effect will come into the play. And how does a person exercising or aspiring to exercise freedom of expression defend himself or herself from the charge of defamation? So do we have the right to hurt? Do we have the right to insult another person? So is the right to reputation so sacrosanct that you have to compromise with the freedom of expression, which is the lifeblood of any democracy? So if you read section 499 IPC carefully, it has got various subsections, like exceptions, and there are many grounds in which it says that it has to be narrowly construed, because being a crime, it should not be broadly construed. Therefore, you find that one provision deals with whether there can be an imputation against a collective. What do we mean by that? So if you read the Supreme Court case of S. Kushbu versus State of Tamil Nadu, you find that the appellant in that case had made certain remarks in the course of her interview to the newspaper, in which she said that the women of Tamil Nadu had premarital sex. This observation made in the course of an interview was misinterpreted to mean as an insult to the entire women of the state. So some people went to the court, and the Supreme Court finally said, no, it is not defamation, because the women of Tamil Nadu do not constitute a specific class, specific community a collective. So that it is a very big collection of people. So you cannot claim defamation on the basis of this vague collection of people under the law. So this is one, safeguard which you can readily identify in the Indian Penal Code. So in Section 499, because it has these safeguards inbuilt in the form of explanations and exemptions. I'm not going into all the explanations and exemptions now because of paucity of time, but you can go through this and make the necessary connections. So the Supreme Court in that defamation case, this is Subramaniam Swamy versus Union of India, also justified the legal provision of against defamation in terms of fraternity. Fraternity in the sense guaranteed by the Constitution, and also as a part of the fundamental duties listed in the Constitution. It is said that a person has a duty to respect the dignity of another individual. Therefore, when you make an imputation which affects the reputation of another person and there is no basis in truth, so basically it is against fraternity. You are not respecting the dignity of another person. Therefore, it needs protection in the form of law. So that is what sections 499, 500 do. Sections 499, 500 may be pre-colonial laws which have lost relevance in many parts of the world. In many parts of the world, the criminal defamation has ceased to be a crime. But in India, the courts have supported this right to reputation as being an important ingredient of Article 21, and as a result, Section 499 and 500 have, been protected as constitutional provisions. So, therefore, in the contemporary scenario, when freedom of expression and freedom of speech is being threatened day in and day out on the basis of defamation, so many opinion makers have suggested that is it not the time to do away with this pre-colonial law which has lost its relevance. Now, it has got both proponents and opponents. If you look at the way in which courts have taken cognizance of the crime without application of mind, without applying the necessary due diligence to ensure that the provisions of law, the safeguards provided in the law, are complied with whenever somebody complains of defamation. Okay, so whenever somebody complains of defamation, and if those safeguards are not looked at, and simply a notice is issued, and simply the speaker is asked to respond and to the allegations of defamation, what happens is that it has got chilling effect, and as a result, the speaker imposes restrictions on the speech, and as a result, democracy, the quality of democracy suffers. Because the quality of democracy suffers, the overall quality of the living will also suffer. So is that restriction reasonable? Under Article 19.2, we can impose restrictions pertaining to those specific grounds under Article 19.2, but those restrictions have to be reasonable. So in Shreya Singhal versus Union of India, Section 66A of Information Technology Act was challenged on the ground that it violates Article 19.2 because it is not a reasonable restriction, because the restriction imposed by this particular provision in the Information Technology Act does not relate to any of the specified grounds. But in defamation, the Supreme Court said it's not a relevant argument because the ground specified is an incitement to crime. If incitement to crime is an offense, defamation is an offense, therefore it is covered at Article 19.2. So friends, this is broadly the picture of defamation as we have in the country today, and whether or not defamation will cease to be a crime remains to be seen, because the Subramanian Swamy judgment was decided by a two-judge bench, and going by the Supreme Court's jurisprudence, we find that judgments rendered by smaller sizes of benches are later on reversed by larger benches if a new ground is cited, or some argument or some issue was ignored by a smaller bench, and if it is pointed out to the Supreme Court that the case needs to be referred to a larger bench, the Supreme Court takes another look. That is what happened to the right to privacy. Right to privacy for a long time was considered not part of the fundamental right. But later on in the Puttaswamy case, the petitioners prevailed on the Supreme Court to take a hard look, and if it is necessary, change the jurisprudence. So the Supreme Court did that through a 9-judge bench and declared right to privacy as a fundamental right. So therefore, I would not say that defamation will continue to be a crime, a criminal offense, because as the society matures and people think that it need not be an offense, there are other remedies for the persons aggrieved under the Act to claim, not necessarily in terms of restrictions on the freedom of expression and speech, and the Supreme Court would like to take another look at his own decision, previous decision by a 2-judge bench in Subramanian Swamy versus Union of India. Thank you. Okay.